CRJ 225. This is the podcast guide for week number 2 of criminal law. This week we are looking at elements of a crime and criminal liability and the concepts of these two things. You've heard of elements of a crime. You probably have seen some elements of a crime in other classes. You probably know what I'm talking about, but just to kind of break it down a little bit, an individual commits a crime if he or she acts in a way that fulfills every element of an offense. The statute establishing the offense also establishes the elements of the offense. In general, every crime involves 3 elements. First, the act or conduct, the actus reus. Second, the individual's mental state at the time of the act, mens rea. And third, the causation between the act and the effect. Typically, proximate causation or the but-for causation. It was either a direct proximate cause of whatever the result was, the injury, the death, or but for that person's actions, that thing would not have happened. Those 3 are going to be present in criminal acts. And we're going to break this down a little bit and explain how we need to understand both the role of elements of a crime and then how that leads to criminal liability. As an example, we've discussed that crimes came from the common law and in the United States are now statutory, with each state having its own criminal statutes and the federal government as well. But if we were to look at common law battery, and if you don't know what I mean by battery, you're going to figure that out real quick. You know, but common law battery, the elements for common law battery are the defendant acts, okay? They do something. The defendant intends to cause contact with the victim. All right, their act was intentional to cause contact with the victim. The contact with the victim is harmful or offensive. Harmful or offensive. And I'll break that down a little further in a minute. And then the defendant's contact causes the victim to suffer a harmful or offensive result. Or, as I was taught these elements, and this is exactly how I memorized them to spit them back on an exam back in the day, a harmful or offensive unpermitted touching of another. So let's break that down just for a second. Harmful or offensive. Harmful we can visualize, right? When we think of battery, we think of, somebody getting popped in the eye or the nose, or and somehow being struck in a way that leaves a mark or a wound, a bruise. Okay, that we can visualize. But it also says offensive. If someone spits on you, is that a battery? Well, hopefully it's not harmful. Hopefully you can wash it off and get past it. But is it offensive? Absolutely. Okay, so know that. Know that that's part of the task here. Knowing what these elements are and then whether you have the facts to back those elements up. Now, the Illinois statute for battery, which we will cover in greater detail later in the semester, provides at 720 ILCS 5/12-3, a person commits battery if he or she knowingly without legal justification, intent, that's what that's saying, knowingly without legal justification, by any means, so whatever the circumstances are, they're doing it knowingly and with no legal justification, and they cause bodily harm, or they make physical contact of an insulting or provoking nature. Insulting or provoking nature. So insulting is that spit, right? You spit on somebody. Provoking, may be the shove in the chest that causes the other individual to come back with the swing of the fist. That's simple battery. It's a Class A misdemeanor. We'll get into the full breadth of that offense later and see that it can definitely go to felony stage, but those are the elements in Illinois. For someone to be charged with having committed a criminal offense, we need to show facts that indicate the elements for that offense to have existed. For someone to be convicted of an offense, we must prove beyond a reasonable doubt that those elements existed. Let's review the burdens of proof. Again, this is something that you may already have a good grasp of, or you should if you don't. But in criminal cases, we deal with the burden of proof of beyond a reasonable doubt. Now, some students may have had or may be in currently my civil litigation class, which deals with procedures and how we navigate litigation on the other side of the courthouse, the civil side of the courthouse, which is anything that's not criminal, including family law, divorce, etc., probate, and then all the things that you see lawyers advertising on television for that they will represent you in court, accident cases, etc. Now, on the civil side, typically the burden of proof is preponderance of the evidence. On the criminal side, it's beyond a reasonable doubt. So I want you to do something for me. As weird as it may sound, play along. Hold your arms out to your sides, palms facing up. Keep your arms level at shoulder level. Okay, so shoulder, even with your shoulders, hands pointed towards the ceiling, palms open. Those are your scales of justice. For a civil case, lower your left hand just slightly below your shoulder and raise your right hand just slightly above. Preponderance of the evidence. The scale has to tip just a bit, one way or another. Now go back to level. This time, I want you to lower your right hand, palm facing up, as low as you can go, while your left hand gets raised to the sky as high as you can go. That's the scales of justice at beyond a reasonable doubt. Very different. Very, very different. And remember that. That's our burden in proving these elements in these cases. Now, if the facts to support the elements exist, we have to determine criminal liability. What does criminal liability mean? In its simplest terms, if you are criminally liable, you may be held legally responsible for breaking the law. This can be potential or actual responsibility, meaning you actually committed the crime or you are suspected of committing the offense. So we know there are elements for the various criminal offenses, but what helps us determine if someone should be legally responsible for that offense? For this topic, I've asked you to take a look at the Illinois Criminal Code Article 4, Criminal Act and Mental State, which attempts to guide us through the primary considerations of whether someone should be criminally liable. I've asked that you go to the statute and read the whole statute before reading my summary that's provided in the document for this week. But I'll go ahead now and break down that statute. So Section 4-1, titled Voluntary Act. It states that a material element of every offense is a voluntary act, which includes omission to perform a duty which the law imposes on the offender and which he is physically capable of performing. So what that's telling us is that in order to charge somebody or to arrest somebody or to seek criminal charges against somebody, in addition to the elements, we must determine whether it's a voluntary act or omission. You can be charged with a crime if you fail to do certain things. And we'll see that when we get into the elements of the various offenses and talk about the various offenses in the coming weeks. Section 4.2 covers possession. We have a lot of possession criminal charges. Possession is a voluntary act if the offender knowingly procured or received the thing that's possessed, or the offender was aware of his control of that item for sufficient time to have been able to terminate its possession. We see this come up in vehicle arrest all the time. Someone has control of the vehicle. It's their vehicle. They have other people in the car. There's some sort of contraband in the car, some sort of illegal activity or illegal thing related to the car, and the owner claims no knowledge or responsibility. And neither does anybody else. Well, it's their car, and so most often, unless somebody else, fesses up, or the owner helps the police determine who the thing belongs to, they're going to be faced with the charge of possession. So that's an example. Section 4.3, or 4-3, deals with mental state. Under Part A, a person is not guilty of an offense other than the offense which involves absolute liability, unless with respect to each element described by the statute, he acts while having one of the mental states described in 4.4 to 4-7, which we'll get to in a minute. So you have to have the proper mental state, the mental state that's described in this statute and expected in a particular offense. Under B, if the statute defining an offense prescribed a particular mental state, without distinguishing among the elements of that statute, the prescribed mental state applies to each element. So in some statutes, as we'll see, there's a particular mental state applicable to that offense. It's an element of that offense. C discusses knowledge. Knowledge that certain conduct constitutes an offense, or knowledge of the existence, meaning, or application of the statute defining an offense is not an element of the offense unless the statute clearly defines it as such. So in other words, knowing that it is an offense, unless the statute defines that that's an expectation, that doesn't get you anywhere. 4-4, intent. A person intends or acts intentionally or with intent to accomplish a result or engage in a conduct described by the statute defining the offense when his conscious objective or purpose is to accomplish that result or engage in that conduct. So we're looking for facts that show that this was an intentional act. It was a conscious objective or a purpose to accomplish the result or engage in the conduct. Either or. Either they intended to engage in the conduct and that criminal liability resulted, or they intended to pursue the result. Steal the item. Okay? They intended to accomplish the result. We have to have the facts that show that. And you'll see that when we get into looking at cases and the statutes on particular offenses a little more clearly. 4-5 talks about knowledge, and a person knows or acts knowingly or with knowledge of when, under A, the nature of attendant circumstances of his or her conduct described by the statute defining the offense, when they're consciously aware that the conduct is of that nature, or that those circumstances exist. And knowledge of a material fact includes awareness of the substantial probability that the fact exists. So there needs to be knowledge. Again, facts. Facts are going to show that somebody has knowledge of a material fact, that somebody has an awareness of their conduct. Facts are going to bear that out. And then under B, the result of his or her conduct described by the statute defining the offense equates to knowledge when he or she is consciously aware that the result is practically certain to be caused. All right, that causal connection. When they are consciously aware. Now, that doesn't say that people can't do dumb things and not see what they should be consciously aware of. And we're all familiar with that sort of circumstance, probably done those sort of things ourselves. If we have to be, brutally honest, there are no angels. But the point is that it's not an excuse that you didn't foresee the result of your conduct. Conduct performed knowingly or with knowledge is performed willfully within the meaning of the statute, using the term willfully, unless the statute clearly requires another meaning. Now, willfully means that somebody didn't force you to do it by threat of bodily harm, okay? Essentially, you were a willing participant. When the law provides that acting knowingly suffices to establish an element of an offense, that element is also established if the person acts intentionally. And again, facts. What are the facts? And how do facts come to us? Those of you who have my evidence class know that facts come to us by people, by their voices, their actions. Persons that you can think of as going to the witness stand, suspects, witnesses. Okay? That's how we get to those facts. 4-6 talks about recklessness, and 4-7 talks about negligence. And I'm not going to, and then 4-8, ignorance or mistake. I'm not really going to get into those at this time. We will get into those when we get to other sections of the course. But you should read my summaries on those parts and know that those are in the exceptions area. All right? Those aren't the things you're going to deal with most often. And absolute liability as well. There is, a body of offenses and defenses to offenses, and we'll talk about defenses at a later time as well. But they are exceptions to what you will deal with most often on a daily basis. So to sum it up, we need to know the elements of criminal offenses, or how to verify the elements. And how do we do that? We look it up in the statute. Obviously I memorized the basic elements of battery a long, long time ago. I don't ask you to memorize elements of crimes to spit back on an exam in my version of this class, because while it is important that you're able to recognize whether something is a battery or an assault, and be able to write a report or to analyze a report or to review witness statements for preparation for trial, or whatever it is you're going to do with this knowledge as you get into your career, it's always important to go back and verify the elements as they exist at that moment. Because guess what? Battery is as old as the human race. But that statute can change. So, how do you verify the elements? Look up the statute. Always go back to your statute. It's easy for you to do. You can do it on your computer in your squad car, computer on your desk, your phone. It's easy to do. I used to carry around, the statutes used to be called the Criminal Statutes Chapter 38, and I would carry around a copy of Chapter 38 and go to that before I ever wrote a report. When I was then moved on to being on the lawyer side of things, I would go to the statute. I still go to the statute. Look it up. Then we need to review the facts of an incident to determine if the elements are an offense, if an offense existed. If the elements of an offense appear to exist, and I use the word appear, we review whether the suspect is criminally liable by reviewing the expectations of that applicable statute and things related to causation. This is a building block week, and if you've had me for administration of justice or evidence, you know I use that term a lot, because in the law and in justice, we have building blocks. We have certain things that we have to have as our base, our foundation, before we move on to more complicated things that we build or add on to that base. This is such a week. So get these things down, spend time with the assignment. The assignment's going to help you flesh out some of those particulars of what I just discussed and what I provided in the summary document that is your reading for this week. Stay well. You know where to find me.